So this is one of the big areas for you guys. Choose the relationship wisely. If you have to do an independent contractor relationship in circumstances where you know there's going to be a risk, understand the risks, be aware of them, and make sure you've got good documentation that has some good indemnity provisions and some good provisions that kind of say, well, if despite the fact that we don't think we're anything, if despite the fact that we think we're in an independent contractor relationship, a court or a government agency finds that we're not in an independent contractor relationship, then this is how it's all going to play out. That may or may not help you down the line, but not having it is not going to help you at all. What is reasonable notice? If an employer wants to terminate somebody on a without cause basis, they either have to give them advance notice or compensation in lieu or some combination of both. Compensation in lieu is not a base salary number. Compensation in lieu is all of the compensation elements that that person would have received if you'd given them a proper amount of advance notice. Reasonable notice is the legal default position. It's not employment standards. Confidentiality and IP, inventions protection, is your first priority. If you don't spend your money on lawyers to help you with anything else at all forever, or at least in the first stages, spend your money on that. Because if you don't protect your IP, you have, in the technical legal term, diddly squat. So that's where your first priority is. If you screw up on an employment contract, it's just money. It's just money down the line to an employee. I'm not minimizing the impact of that, but it's something that's solvable by money. And if you have no money, then the employee can't solve it anyways. If you screw up on your IP protection, you've lost your assets. You have nothing to sell, nothing to finance, nothing to leverage. So it's really important. If you have no paper at all, invisible contract, common law, there's actually reasonably good protection under the common law for confidential information. Employees owe a duty of good faith while they're working for you, and that means they are not allowed, while they're working for you, to misuse your confidential information. And it also means after they leave you, they're not allowed to misuse your confidential information. The fight is what was confidential, what isn't, and can you prove it? The law will enforce reasonable written non-solicitation obligations, but the law for most employees, and when I say most employees, I mean 90-something%, most employees, the law will not enforce a written non-competition obligation even if you pay somebody for it, even if they agree to it. It just won't be enforceable because the law will say, we think in most cases a good non-solicitation, you will not go and raid our customers, you will not go and raid our staff and try to take them away from us to hurt us. We think a good non-solicitation is enough, and so we're not going to go any further. We're not going to encroach on this person's freedom any further than we have to. In exceptional circumstances, and that's actually the wording the courts use, we will only enforce non-competes in exceptional circumstances. What does that typically mean? Typically means really, 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 really key employees. You may think you have 20 key employees when you're a startup with 50 people. You probably have 3. So it's not what you think it is. You've got to be really careful. If you have nothing on paper, everybody can compete. Doesn't matter if they're the CEO. The second they leave your organization, they can compete. They can open up a competing company. They can join a competitor. They can't misuse your confidential information, but otherwise they can compete. If you have nothing in writing at all ordinary employees can solicit. They can leave your organization and they can start calling and knocking on the doors of the customers and suppliers and their friends that were working back at your organization. Again, as soon as they leave, they can solicit as long as they don't misuse your confidential information. A small subset of human beings, people who have really key decision-making power in your organization, people that are considered by law to be fiduciaries. C-level people are fiduciaries. As soon as you get down underneath C-level, whether they're fiduciaries or not is going to depend. Usual lawyer weaselly stuff. Fiduciary will, even in the absence of anything in writing, a fiduciary will have, for a reasonable period of time, an obligation not to solicit your customers and your staff away from you. What's that reasonable period of time? Not a long time, maybe somewhere 3 months, maybe somewhere 6 months, not usually longer than 6 months. So you don't want to be counting on that, but at least if you have no paper at all and your CFO leaves you, you at least have something nasty to say to this person if they start going out and soliciting afterwards. But because you are essentially not protected at all, if you don't have paper, it's open game season on you. So you're not completely protected without paper. While the employment relationship is going on, people owe a duty of good faith. I mentioned that before. They can't try to hurt you while they still work for you. So they can't try and set up a competing business while they still work for you. They can't do bad things to you while they still work for you. They have to try and protect your assets, protect your confidential information. And again, I've said this again, it's important to remember, especially for those of you who've left somewhere with confidential information or copies on your laptops, you cannot misuse your ex-employer's confidential information ever, as long as it's still confidential. So the Kentucky Fried Chicken formula is safe forever. And those of you who use NDAIP agreements, where the NDA obligation expires 3 years after the last disclosure, shame on you. Either something's still confidential or it's not. 3 years isn't a magic number. Shame on you. Don't do that. Okay. There are all kinds of tricks to how you have to write non-competes and non-solicits to try and make them enforceable. Bottom line is this. A reasonable non-solicit shouldn't be longer than 12 months, and if it's reasonable, you can pretty much cover everybody. A non-compete should never be longer than 12 months, should be shorter ideally. Wouldn't you rather have something that looks like it's more enforceable, even if only for 3 months, than longer than that? And you should really only be using it when you're dealing with key employees. If you use it for other people or you routinely include it in all your documents, go right ahead. But a court's going to say, I'm not enforcing that. And if you've mixed it in with some of your stuff that would have been enforceable, now you've screwed yourself over entirely because you're going to have nothing. The court will throw out the baby with the bathwater. Are you signaling me yet? Where am I at? What?
1 minute.
Oh, well, where was my 5-minute warning? Yeah. I didn't get a 5-minute. I'm taking 5 minutes. I can't see on my glasses. Okay, lapse. We talked about crap, gap, and lapse. These are the kinds of things that can create a lapse. You change somebody from part-time to full-time. You change somebody from a contractor to an employee or back again. You change somebody from temporary to permanent. You promote somebody. You transfer somebody to a different thing. You change really fundamentally what it is they're doing within your organization. Out of marketing into sales. Out of this into that. You do impose significant adverse changes, wage rollbacks, freezes, temporary layoffs because you're trying to cut costs. That's one that tripped up a lot of mature companies in town, particularly for those of you who lived through the meltdown back in 2000, 2002. You mistreat employees. If you treat your employees like crap, a court's more inclined to try and find an excuse to toss out your employment agreement. You mishandled departures. You had a beautiful employment agreement, but after somebody left, you trash talked them to all your customers and suppliers. Again, a court's going to find an excuse not to enforce it. So, avoid the risk. Reduce the risk. You can never eliminate the risk, but at least try and control it. Treat people decently. That's just a basic tenet of employment law. If you treat people like crap, bad things will happen to you. If you treat people decently, less likely to have bad things happen to you. Document significant changes of status and keep in mind the same crap and gap rules we've already talked about. Whenever you're doing a change, if I'm transferring somebody, promoting somebody, redeploying somebody, changing them from part-time to full-time, whatever, the paper goes before the change. The sign-off goes before the change. Then the change happens. Again, if you're going to do something that is adverse to somebody, wage rollback, demotion, any of that, speak to your friendly employment law expert to try and find out how you can do it. So that's the process, again, we talked about before. Okay, 2 more minutes. Reality bites. Mel, this is all fine and good, but I already have 97% of the problems that you've talked about because I've already done or not done all the things you said to do or not do. Of course, it happens all the time. There are fixes. With the right planning, the right documentation, the right process, a function of time and sometimes putting some money on the table to sweeten it for somebody to sign, you can actually make changes. You can clean up documents. You can put new documents in place. You can make changes. But it's risky and it's a second best solution. So There are ways to do it, and since I'm running out of time, I won't get into those ways to do it in any detail. The two basic ways are you're giving what's called fresh consideration. I should have actually given you the written employment agreement before you started here. I've given you the written employment 3 days after you started here. I'll give you a signing bonus of $500 if you sign it. You still have to give them reasonable time and stuff, but that's fresh consideration. Has to be something they weren't already going to get. So continued employment is not fresh consideration most of the time. The other way is to give them reasonable advance notice of the change, similar to the reasonable notice concept. If a court would say that you owe somebody 3 months reasonable notice of termination, then a court will allow you to give somebody a letter that says 3 months from now your terms and conditions are going to be different and they're going to be X, Y, Z. I'm oversimplifying. You do need help to do this, but it can be done.